All right, you guys, I was sent this one. Now, sale proceeds of property and trust go to beneficiary's bankruptcy trustee. Ontario Court of Appeal, rights and property were not suspended until discharge from bankruptcy. The Ontario Court of Appeal has agreed with a bankruptcy judge's interpretation of a trust document, finding it consistent with the plain wording of the Bankruptcy and Insolvency Act with the trust's stated purpose. In Richards re 2022 ONCA 216, the appellant was the beneficiary of a real property pursuant to a trust. The trust was set up to hold the property while his parents were alive, with a life interest allowing him to live there. The mother remained in the property when the appellant's father died in 2010. The trustee sold the property with the proceeds amounting to $1,172,120.90 held in trust. The mother died in 2020 under the trust terms. The trustee were required to distribute the trust fund, including the property and any chattels, to the appellant after the death of the second of the appellant. I want you guys to go look up the last video, a couple videos before I made, called Ipso Jur. Ipso Jur, capital I, period, capital P, period, small s, period, small o, jur. Go and look that up, because I think this applies in this case. The respondent's bank had an outstanding judgment against the appellant as an undischarged bankrupt. Oh, before I forget, our injunctions are now available. You guys can go to our new channel, Nobel, over here. We've got them all posted for you. For all cases, child support cases, mortgages, foreclosures, ticket citations, grab the injunction. However, you need to have a bond. Before you serve that injunction, dear God, have a bond, because you're going to ask for the W-9, 1099 OID, and some people got arrested. So when you do the injunction, that's like, yeah, it shuts down everything, right? But make sure you're protected going forward. You got to lean up the straw man, do a trust, and also make sure that your properties and stuff are also leaned up. We leaned up ours for $9 billion. Some people are doing it for $200 billion. But before you lean up anything, make certain if you need a credit card or you got to go for a job or you got to go for stuff, that you're protected before you do the lien. Do not do the lien if you need to get credit card or a job. Just wait first, then do it, right? Email us at themolings@gmail.com. And when you guys email me, dear God, don't ask me to do it for free. It's now 30 years in, you guys. When I started out, it cost me $1,000. Now I'm thousands and thousands of dollars in. People write to me with such foolishness, get themselves in all kinds of hot water, and then expect me, I have nothing to do with it. They're writing me for help, and by the way, will you just do everything they need for free? What the hell do I look like? Hello? Slavery's been abolished, people. All right, and it's against the law. You're writing to someone, make sure you got some bucks in hands, right? Our stuff starts at anywhere from $5 to $3.49, depending on what it is. Yeah, make sure you got some bucks before you write to us, right? Because it ticks me off. I had to pay so much to do this. When I first started, I was like, oh yeah, I'll do this. No, it doesn't work, right? All right, so you can join us here on Boon TV for as low as $5 for the bronze, silver $10, and $15 a month for the gold. Let me see if I can get back to this, because this is quite interesting, this story. The respondent bank had an outstanding judgment against the appellant as an undischarged bankrupt for $987,613 plus costs and interest. The bank acquired an order under S.38. And another thing, you see all these court cases, you got to put them on a UCC. All these applications, they have to go on a UCC. We have done several UCCs now. And I remember when we first started out, people were saying, oh, you don't have to do that. Yes, you do. Okay, so S38 of the Bankruptcy and Insolvency Act, and was successfully assigned the rights of the appellant's bankruptcy, trustee to make a claim against the sale proceeds, also the Minnesota Rule 220. Yeah, that's another thing that's important. The bank sought recovery of the sale proceeds in the amount owed to it and a declaration that the appellant was the trust beneficiary who had an interest in the property under the trust terms. The bank contended that sale proceeds were the bankrupt person's property under the broad definition in S.67(1) in brackets C of the legislation. I just did a whole thing about legislation, and yeah, you need to go look at that injunction. I think you guys should get that. The bankruptcy judge concluded that the real property constituted the appellant's property and was vested in his bankruptcy trustee. The bank was entitled to receive the sale proceeds up to the amount owed because the bankruptcy trustee transferred its rights in the appellant's property to the bank, the judge said. And those of you in mortgages and foreclosures or foreclosure situations, once you get the injunction, write to me at themullings@gmail.com. I will share with you the court claim that goes with that for the people that use their international bills of exchange. I think in the amount of close to 200,000, and won. Yes, people, they won their properties back. Yeah, so you need to serve that when you're serving the injunction, right? All right, now the judge's interpretation, that goes for you guys with child support cases. There's a case that goes with the injunction for all child support cases as well too, right? Write to me at themullings@gmail.com after you get the injunction, right? The judge's interpretation of the trust documents was in line with the relevant section's plain wording and with the trust stated purpose. The appellate court held the appellant's interpretation, of the other hand, would allow bankrupt individuals to place assets out of their creditors' reach and would offend the public policy underlining the legislation. The appellant contended that during the bankruptcy, his rights in the property was suspended, and upon his discharge from bankruptcy, did you hear that word? Discharge from bankruptcy, the property would vest in him under Part 1V of the trust, and he would then own the property outright, because there's only discharge and set off, you guys, in this whole thing. The appellate court agreed with the bankruptcy judge's rejection of the argument. According to the judge, the trust provisions in Part 1V applied to the property during the lifetime of the appellant's parents. However, the provisions in Part V applied to the property after the parent's death. Ipso jure, go and look at that video I created. Then this will fall in, this whole thing will look totally different, right? Ipso jure, you guys. All right, so you guys can write to us at themullings@gmail.com. You can come over here on Nobel and pick up your injunction and then write to me for the documents that goes with. Some of it, depending on what it is, you might have to shell out some notes for those, but the actual court claims, will share that with you, with them. So they're right here, and yeah, you'll see them. I would do this one for child support here, the fourth one here. These ones are private matters, and yeah, so you can do that, and yeah, you can join us over on Boom TV. Like, share, subscribe, you guys. Have yourself a great day, and I'll see you in the next one.